How much does an estate have to be worth to go through probate in California? That's our topic today. We'll get started right after this. The death of a loved one can be quite devastating. However, you may have responsibilities while you're dealing with your grief. You must address the decedent's personal property and all the responsibilities attached with being responsible for your loved one's estate. And this can take quite a bit of effort while you're dealing with your feelings about having lost someone that you cared about. When someone dies, one of the first questions is, how do I handle the estate? In California, does there have to be a probate proceeding? When there is a death in California and a loved one does not have a trust, even if they have a will, in most cases, you will need to go through a probate in California. So then the estate of the deceased person goes through a process called probate. Even though probate is basically the same in every state, each state has its own unique rules and procedures. And here, a probate in California has a specific set of rules and procedures that you will have to familiarize yourself with. So it's important that you know the basics about a probate in California. The second question people have once they understand that they are going to be involved with a probate in California is, how much does an estate have to be worth to go through probate in California? Probate is generally required in California, but there are different types of probates for different types of estates. Simplified procedures may be used if the estate value is less than $166,250. Now, this is highly unlikely and definitely unlikely if your loved one had a home, owned property, real property here in California. A little bit of good news is that a probate in California may not be required if the assets are tied to a beneficiary or a surviving spouse. For instance, life insurance policies that have a named beneficiary do not need to go through probate. The reason is they automatically go to the person named in the life insurance policy as the beneficiary. Real estate owned by a couple would automatically go to the surviving spouse. Again, California does allow for simplified probate process only if the estate value is less than $166,250. If the decedent, and most people will, have a larger estate than that amount, then the assets that are in his or her name, if they are over that amount of $166,250, and there is no surviving spouse, or if the assets were not left to the spouse, in some cases, then there would be a probate in California. Dealing with probate in California can be an overwhelming and stressful situation for those that are not familiar with a probate. Having someone that can guide you through the ins and outs of this process can be really beneficial to you. You'll want to learn everything you need to know, including the costs of having a probate in California. The cost of a probate in California can vary, and it can depend on multiple factors, such as these: the location, the county that the property is located in. Now, I'm in San Diego County, so we have certain rules here. The estate size, the estate complexity, and the type of estate plan or lack thereof. Is there a will? Was there a trust? And there's some other various factors that will be for a specific situation. If it is necessary to have a probate in California, the question is, what are your next steps? And who will be the person that acts as either the executor in the case when there is a will, or the administrator when there isn't a will? I think it's important for you to know that the person that takes on the responsibility of the executor or the administrator does not have to live in California. A friend may serve as the executor or the administrator. You could have a situation where more than one person serves as co-executors or co-administrators. I don't necessarily recommend that. It makes it a little more complicated, but there are cases where that is the reality. And there are cases where a licensed fiduciary is put in place to act as the personal representative for the estate. Another important thing is no one has to serve if they are named in the will. You can decline serving as the executor. The next question is, will the person named in the will they accept the responsibility? Will they serve? If there is someone named in the will, they do have that choice of not taking on the responsibility or possibly transferring that responsibility to someone else. Usually the first people that are looked at to act as administrators when there isn't a will are family members and then perhaps friends. When there isn't a will, the person that is asked to be the administrator must be appointed by the probate court in California. There are times where someone does have a will and they don't name anyone to act as their executor because they don't know that they should be doing that. And sometimes there'll be in a will that a bank or some type of other individual will be named to act as the executor. Just depends on each particular case. When there isn't someone that's specific in the will, then the courts again will appoint someone, typically the nearest relative to the decedent. All of the people that I just talked about that may be appointed as the executor or the administrator, they have a fiduciary duty to the estate and its beneficiaries. They will all perform the same types of duties regardless of how they are appointed. And I didn't tell you, I'm Kim Ward. I am a certified probate real estate advisor here in San Diego, California. Please help my channel by liking, making a comment that I will respond to, and subscribing to the channel. Thank you for watching. I'll see you next week.